All right, it's 11:02. I think we can probably go ahead and get started now. Well, first of all, thank you everybody for tuning in and joining us this morning. Very exciting topic, Fiduciary Refresher, and the latest updates on some of the DOL fiduciary guidance regulations that have been published as of late. My name is Ben Gibbons. I am an executive compensation and employee benefits attorney at Holland & Hart here in Boise. My practice covers, kind of broad range of benefit plan matters, from retirement plans, health and welfare plans, non-qualified deferred compensation plans, anything equity related, and really, anything else in between that fits in that benefits space. I am a relatively recent transplant to the Boise area. I came by way of Boston and moved out here for a lifestyle change, and I got to enjoy that full Boise experience for about 9 months before COVID shut it all down, and now I am desperately looking forward to things returning back to normal so I can go out and enjoy Boise. That's one of the reasons I came out here. With that, we will get going, and I would not be a good lawyer if I didn't throw a legal disclaimer in my presentation. So here it is. In a nutshell, nothing I'm saying today is to be taken as legal or financial advice. It's purely for education. And the views I express today are my own views and not the views of Holland & Hart. So the presentation today is really going to be divided into two parts. The first is, and you can probably hear I have a dog. Mel must be here. The first part is a fiduciary refresher, which is going to cover just kind of the fiduciary basics, run through what it is to be a fiduciary, the responsibilities of a fiduciary, and the consequences and defenses to breaches of fiduciary duties. And then we'll spend some time covering some of the new guidance that's come out recently at the end of last year, beginning of this year. So there's new guidance around investment advice fiduciaries, a new prohibited transaction involving rollovers from plans to IRAs. There is new ESG fiduciary guidance that came out, and some guidance on proxy voting. So we'll touch on all of those as well. All right, so for the first part, you might be asking yourself, why does it matter? Why should plan sponsors and fiduciaries be paying attention to this stuff? Well, first reason is the Department of Labor. Last year, at least in fiscal year 2020, the DOL had a 67% success rate in finding breaches of fiduciary duty on audit, which, is a pretty high number, especially when considering they looked at 1,100 plans last year. And, when they come out to do an audit, they're going to be focused heavily on whether or not, a plan and plan sponsors are meeting their fiduciary duties. And they'll ask whether or not they'll try to find out what sort of fiduciary training fiduciaries have had. And if a company says none, the DOL is absolutely going to scrutinize everything a little more. So it's really important to be aware that the DOL is absolutely focusing on fiduciary responsibility and compliance with fiduciary duties, and they're definitely looking for it as part of their audits. And they will audit plans on random. It's not only, there's probably are some things in the 5,500 filings that do tip them off, but they certainly do select plans at random as well. Perhaps an even more important reason why it matters is the risk of litigation. In particular, you don't want to be receiving a letter from Schlitzer Bogard or Capozzi Adler, or one of the other plaintiff firms that are constantly now bringing fiduciary breach claims against plans and their fiduciaries. It's really for the last decade now, these plaintiff firms have just kind of relentlessly attacked fiduciaries and plans over potential fiduciary breaches, most of them involving investment advice and investment fees. And at this point, it's becoming more common to see lawsuits filed against not only the mega plans, and they've had their fair share of litigation, they're still getting sued, but also they're targeting other smaller plans as well, or certain niche areas. Like a couple of years ago, they kind of went off on their 403B plan thing, and they used lots of 403B plans. But last year alone, there were over or nearly 100 fiduciary breach lawsuits that were filed. And these guys that I've listed here are responsible for a good deal of those suits. And in fact, one of our clients was sued over investment fees by Capozzi Adler, and we got a little insight into how it works. And what at least Capozzi Adler was doing is they were sending emails out, because we got a copy of one, to individuals who had recently terminated employment with the company, and assume they must have found this out on LinkedIn, and that's probably also where they got their email address. These emails would say, hey, we're a law firm and we're considering bringing a class action suit against your former employer due to excessive investment fees that were uncovered as a result of a recent UL audit. Well, there was no recent UL audit, and even if there was, the folks at Capozzi Adler wouldn't have had access to any of those results of that audit. So, essentially, they're just out there trolling. They're probably identifying these plans based on 5,500 filings that have a sufficient amount of assets, and whatever little bit of information they can glean on fees from Schedule C of the 5,500, and then they're out there trolling former participants, former employees, in hopes that there still are plan participants to get involved in these lawsuits. And these emails that they were sending, at least our clients' former employees, also said, well, you don't get compensated if you're in a class action lawsuit just for being in a lawsuit, unless you're the named plaintiff, in which case there's some extra obligations and duties you have, so you could earn up to $45,000. Please give us a call if you'd like to talk about it. Thanks. And obviously, in our case, one of our clients' former employees decided to give them a call, and they've moved forward with that lawsuit. So this is a company that has very good fiduciary practices. We work with them on it all the time. So it just goes to show there's no, being very small maybe is the best way to protect yourself. But, if you're a decent sized plan, there is potential, and these firms are out there that are going to try to capitalize on it. And part of the big reason for that is that, as you can see in my slides, that they've recovered $77 billion in attorney's fees as part of settlements over the recent years. And obviously that's a pretty big incentive for plaintiffs' attorneys to get involved here. And the other thing, actually, I think I might have this on 2 slides. The third reason why it matters and why plan fiduciaries should care is that ERISA fiduciaries are personally liable for damages. So again, if those first 2 reasons weren't scary enough, then hopefully personal liability will be. So who are plan fiduciaries? Some of them are pretty obvious. Your typical fiduciaries include plan sponsor, plan administrator, trustee, and investment advisors. So that would be ERISA 321 and 338 fiduciaries generally, or at least they definitely will be fiduciaries. 321 fiduciaries are investment advisors that make recommendations, and 338 are those that have the authority to actually make the investment decisions and move into a fund or remove a fund. Oh, it occurs to me too, I didn't mention in the beginning, but if anyone has any questions, feel free to I think we have the chat feature enabled. Feel free to throw it in the chat, and if I catch it while I'm presenting, I will certainly respond, and if not, I'll take them at the end. Back to the presentation. When we're talking about who is a plan fiduciary, kind of the overlooked fiduciaries sometimes are these functional fiduciaries. And these are often fiduciaries that exercise authority over plan management or the disposition of plan assets. They have the discretion or authority or responsibility over plan administration, or they provide investment advice for a fee, but they weren't any of these named fiduciaries that we just talked about on the previous slide. So oftentimes, they have no idea that they're fiduciaries. And this can happen if, for example, the the plan sponsor is the named fiduciary for the plan. Ultimately, that fiduciary responsibility usually rests with the board. And if the board hasn't delegated it and, they're just letting HR, finance run with all plan decisions, the board's completely uninvolved, not paying any attention to it, then, those HR finance professionals that are making these decisions would be functional fiduciaries, and they would be subject potentially to fiduciary liability and be completely unaware of it, because they just not they haven't been trained and they don't know that it's their responsibility. So a lot of times what companies will do is form committees to kind of draw a fence around who is a fiduciary and who's not. And we'll talk a little bit about committees later. But just, even if it's just positions like the director of HR, that's a fiduciary, just to try to make sure that everybody's on the same page. I mean, it's very important for companies to determine who their fiduciaries are. Because again, it just really, you want to understand that for a number of reasons, particularly with the defense of any fiduciary breach claims. And also fiduciary insurance matters, which we'll talk about in a little bit as well. Here's some individuals that typically are not fiduciaries. These would be record keepers and TPAs, insurers, lawyers, accountants, anybody providing a general investment education. But be aware, and we'll talk about this later, once you start providing specific investment recommendations, specific to a plan participant, then that is fiduciary advice. And that line can get kind of blurry, and part of the new DOL guidance is to help clarify that, so to better define who's an investment advice fiduciary and who is not. So not every action is a fiduciary action. For example, ministerial acts are generally not fiduciary in nature. So that would be things like applying the rules for determining eligibility for participation in a plan, calculating service, calculating plan compensation, preparing communications or processing benefit claims, anything like that. That typically, there's not really any discretion involved there, and those typically would not be a fiduciary act. Some more acts that are not fiduciary in nature are settler functions, and fiduciary duties never apply to settler functions. And these would include things like plan design changes, deciding to amend a plan, unless it's a required amendment under the tax code, deciding to terminate a plan, deciding whether or not to make contributions to a plan, and any sort of actuarial or accounting assumptions for DB plans. Those would all be settler functions and would not be subject to any of these fiduciary rules. On the other hand, some fiduciary acts would be any exercise of discretion in interpreting plan terms or deciding benefit amounts, oversight of other fiduciaries. It's important that all fiduciaries are monitored by ultimately whoever has responsibility, which usually rests with the plan sponsor. The selection of service providers that are paid with plan assets, that's fiduciary responsibility. Reviewing investment fees and investment lineups, fiduciary claims and appeals, and actually implementing settler decisions are fiduciary acts. So, for example, a settler can decide to merge a plan, and they can do that with impunity. It's not going to be subject to any sort of special duties, but the actual implementation of that merger, making sure that merger goes the way it's supposed to, and meets all necessary requirements of the tax code, for example, that would be a fiduciary act. And it's important to know what's fiduciary and what's not, because a lot of fiduciaries are wearing two hats. They're wearing their settler hat, or they're working for the company, and they're wearing their fiduciary hat. When they're wearing their settler hat, they're not obligated to act in the best interest of plan participants. But when they're wearing their fiduciary hat, they're 100% obligated to act in the best interest of plan participants. It's also important to note that plan assets can't be used for settler functions. So if a company decides that it wants to add a new discretionary employer contribution to their plan, they can't pay for the cost of preparing those amendments with plan assets. But they can pay for the actual implementation of that plan to the extent they need to message participants and update SMMs and that sort of thing. Those are fiduciary acts, and that sort of thing could generally be paid with plan assets. And also, it's worth noting that there's a difference when we're talking with settler and fiduciary actions as to attorney-client privilege. There is an exception to the attorney-client privilege, which we're generally, well, attorney-client privilege, as you know, we can't, upon discovery, if there's a lawsuit, we can't be compelled to provide any sort of privileged communications between a plan sponsor and their attorney. There's an exception to that for fiduciary acts. So if an attorney has been consulted on fiduciary matters, the fiduciary exception provides that sort of thing can be discovered by opposing counsel, and it is not subject to attorney-client privilege. Any settler discussions or matters, that would be subject to attorney-client privilege. So just be aware that there is a difference there. I'm going to spend just a little bit of time on ERISA fiduciary duties. I think a lot of us have heard these before, and these in particular here on this slide anyway, are the duties that are codified in ERISA. So the first is the Dewey of Loyalty, or the exclusive benefit, and that is where fiduciaries must act in the best interest of plan participants, and they're not permitted to be involved in any sort of self-dealing with the plan. So any sort of direct or indirect benefit a fiduciary might derive as a result of working with the plan or causing the plan to enter into transactions, that's prohibited. That would be a violation of the duty to loyalty. The other piece of this duty is the obligation to defray plan expenses. So plan sponsors should always be looking at making sure that their fees that they pay with plan assets are reasonable. And if they're not, there's probably a fiduciary breach there. There's also the duty to act prudently, or the duty of care. So you have to act with care, skill, prudence, and diligence. And the most important part when doing this is documenting that you're actually doing it. And we'll talk a little bit about documentation later. But documentation is extremely important to demonstrate that you've actually acted in a prudent manner. Absent documentation, it's going to be hard to prove in the event of a lawsuit that as a fiduciary that you acted the way you're supposed to. You met your fiduciary duties under ERISA. So documentation is key. Fiduciaries also have a duty to diversify plan investments. So to avoid the purpose is to avoid the risk of large losses. But at this point, I think certainly in the 401k space, you're going to see, generally, you will see well-diversified plan investment lineups. And fiduciaries, lastly, have a duty to follow plan documents, unless, of course, they're inconsistent with ERISA. There are other fiduciary duties that have been established through case law, and here's just a few of them. There's a lot more gloss that could be gleaned on those other duties we just talked about as well. If you dig into the case law, there's, I think, beyond what, this kind of brief overview that I'm trying to present today. But anyways, in some case law where it's, some pretty relevant duties that come out of it, there's a duty not to misrepresent. There's a duty to respond truthfully to questions from plan participants. And there may be a duty, if there's changes in the works to benefit plans that are under serious consideration, there may be a duty to disclose those upcoming changes. Kind of a common example of that would be, you'd see this a lot historically in DB plans where a participant was getting ready to retire, and they'd go to HR benefits and say, hey, I'm thinking of retiring at the end of next month. Can you tell me what my pension benefit's going to be? Is there anything else I should know? And the HR person knows that the month after they retire, the plan is going to put a new early retirement incentive in to pay participants an extra amount of money if they retire early, just so they can get them out of the plan. So if that sort of early retirement incentive is progressed enough where it's into a serious consideration, then that HR person may have a duty to disclose to the participant that that is in the works, because that would affect probably when they're going to retire. They'd probably wait an extra month to retire to get that benefit. There's been a lot of lawsuits over the years around cases like that, and there is somewhat of a facts and circumstances test, but just know that it's out there. So if there is a big change in the works and someone asks, oh, is there anything else I should know? There might be something else you need to tell them. Oops. Know also that you should be aware that there is potential for prohibited transactions with fiduciaries. Under ERISA, there are certain transactions a plan cannot enter into with a party in interest. Some of those in a party interest would include fiduciaries. So that would be buying stock from a company or shareholder, or paying a related party to perform services for a plan. Fiduciary investment advisors that invest in plan assets, or they have plan assets under investment, if they receive commissions, based on moving to an insurance policy, for example, that would probably be picked up as a prohibited transaction, unless, of course, there's an exemption. And there are statutory exemptions, and there's also class exemptions which apply to everybody, and plans can apply for individual exemptions that just apply to those plans. But there are a number of exemptions that do provide some relief. So you can provide goods and services or receive goods and services from related parties as long as the plan pays fair market value for those goods. They're paying in excess, and that's probably a prohibited transaction. And consequences for the breaches of fiduciary duties. There's a number of consequences. We kind of touched on those in the why it matters slide as well. But just going back to prohibited transactions, there is a 15% excise tax that the IRS can assess if there's a prohibited transaction on the amount involved. So if it's a particularly large amount of money, and I've seen before where a plan, wants to, with DB plans, sometimes they're trying to invest in certain funds and private equity funds. They don't have enough money. I've seen it before. They pooled their money with the company to meet the minimum investment requirements, that sort of thing. That would be a prohibited transaction. And if you're talking with millions of dollars, that 15% excise tax can be pretty substantial. There's, of course, the risk of lawsuits. And as we talked about before, fiduciaries have personal liability to the plan. So they can be sued by participants. They can be sued by the Department of Labor, co-fiduciaries, employers. And also the DOL can assess penalties of up to 20% on the amount recovered in the event of a fiduciary breach. And finally, although ERISA generally limits remedies to equitable relief, they can also include a surcharge, also known as monetary damages, on top of that. So there are a number of civil penalties and risks as far as litigation goes that could arise. And the last is criminal liability. And this most often comes into play when we're talking about embezzlement. But you see it from time to time. The DOL does put out their press releases when there's some interesting criminal or civil penalties that come out. And a fiduciary can get up to 10 years in prison and up to $100,000 in fines for an egregious fiduciary breach, on top of any restitution they need to pay. So if they steal $1 million from the plan, they'd still end up needing to pay that back with interest on top of their jail time and whatever other penalties that are assessed. So know that there's some good consequences out there. One of the more interesting cases that I came across a while ago now involving a fiduciary breach involved a senior benefits manager at a company, public company. They're a good-sized company that, I don't know if he just became overwhelmed or what happened, but for whatever reason, or maybe had a bad experience with his auditors, but for whatever reason, he decided not to engage their 401k auditors for the audit, even though they'd used them in the past, and simply take the previous year's financial statements, update the numbers, and forge the audit opinion and submit that with a 5500. Well, that didn't work out too well for him. The auditors, who are wondering after October 15th, oh, I wonder who these guys went and used this year for an audit, went to check the 5500 filing and saw that, well, they had issued the audit opinion when, of course, they hadn't. That ended up in them contacting the DOL. The DOL, of course, investigated the company, and they actually cleared the company of any wrongdoings. But last I heard, and I don't know whatever happened to it, but they were potentially pursuing some civil penalties against this individual who had filed these forged financial statements. Of course, with 5,500 under the pains, he was the one signing it, so under the pains and penalty of perjury. I don't know what he ended up paying, but it didn't work out for him either in the sense that he was certainly terminated from his job, and probably it's tough to get another job in benefits when you have this on your record. So there can be real consequences for fiduciary breach. Now, the best defense for fiduciary breach is documenting the prudent process. Again, I touched on before, if you don't document it, there's no way to show that you acted prudently. So fiduciary decisions, they're not judged in hindsight. The emphasis is not based on the results. So even if you had great results or if you had horrible results, as long as you can show that the process you used to arrive at the decision was sound in the first place. So it's really incredibly important, I can't say enough, to make sure you have that process in writing. So you can pull that out, show it to the DOL, or you can produce that in the event of a lawsuit and say, hey, well, yeah, things didn't work out the way we planned, but we took all these precautions. We have documentation right here that we did it. So therefore, we acted prudently. There's no breach. And keep in mind too, things that aren't necessarily a defense, but certainly help with the defense is that if you have a retirement plan committee, make sure they get fiduciary training. Well, even if just with your fiduciaries in general, fiduciary training is a good idea. Make sure that they have access to their plan documents, they've read the plan documents. If we're talking about a committee, meet regularly, review investment fees, and consult with experts where need be. We'll talk a little bit more about committees in a minute, but again, these are kind of all things that plan sponsors and fiduciaries should be thinking about when they're administering their plan. Now, some other protections for fiduciaries. There's always co-fiduciaries, so you can always push some of that fiduciary liability off onto another party. Some common examples of that would be 321 or 338 investment advisors. Those advisors will have fiduciary responsibility to some extent, at least, with respect to the investment options offered by the plan. With the new pooled employer plan, the PEP plans that are starting to roll out now that were, came out as part of the Secure Act a couple of years ago. Those were effective this year. That's another way where a fiduciary can push some of those fiduciary responsibilities onto another party. With PEPs, the pooled plan provider, the person essentially in charge of the PEP, needs to be a named fiduciary and the plan administrator. So they absorb a lot of the fiduciary duty from plan sponsors there. And I should add, if somebody does eventually move into the PEP, they're pretty new now. I don't know how many plan sponsors have moved in the PEP direction yet, but I suspect a lot will in the near future. Just be aware, though, as a plan sponsor, you still would have the fiduciary duty to monitor the pool plan provider. So your fiduciary duty never completely goes away. You always have to monitor. It's just you can offload some of that risk, though, if you do delegate it to a co-fiduciary. Fiduciary liability insurance is another fiduciary protection, rather. And this is different than ERISA bonding. The ERISA bond just covers the theft of plan assets. Fiduciary liability insurance is actually going to cover, fiduciary breaches. And, I actually just listened to a presentation where there was a underwriter for an insurance company speaking, and they mentioned that now a lot of fiduciary liability policies are providing specific exclusions or where investment fees are too high, where companies should have been offering a lower share class than they actually offer to participants. So it's really important to know what your policy covers and what the exclusions are. And it's also important to know, it's also important rather not to know, but to make sure that your policy covers everybody who's actually a fiduciary. So going back to that kind of functional fiduciary issue, if you haven't clearly defined who the fiduciaries are in the plan, then they may not be covered by the insurance, and they could, commit a breach that's, not going to be covered, which is going to obviously cost the company potentially a lot of money if it ever ends up in litigation. And the last protection for fiduciaries, which is very common, is to provide indemnification to fiduciaries. The employer provides the indemnification. Again, that only works depending how those indemnifications are drafted. Usually, a lot of times that's in the plan, but you want to make sure that, however it's all defined in the plan, that again it is covering all of your fiduciaries, not just those obvious named fiduciaries that we talked about before. So committees, they are just kind of a good thing to have from a governance standpoint. And because it really, again, focuses everybody's attention on who's a fiduciary and what the committee should be doing. Typically, you'll have the board will delegate its authority to run things, to make fiduciary decisions oftentimes to the committee. There might not be even that level of delegation, but it really helps put things in perspective and really helps get everybody on board and know that, hey, we're wearing our fiduciary hat and we're looking at these things. So some things that fiduciary committees should be doing is they should locate, retain, and consult with all controlling documents. So first of all, there should be a charter establishing the committee with that appropriate delegation authority by whoever has it to that committee. But they should track down plan docs, investment policy statements, service agreements, really any related benefits documents, and make sure that they are being followed. If they're not, then the documents should be amended as necessary. It's a good idea if you have a committee to hold regular meetings. Quarterly is generally considered best practice. You can meet more frequently. That's probably going to be too burdensome, but it's got to, at the very least, be at least annually. But quarterly tends to be kind of the sweet spot that most committees do. Committees also help plan sponsors focus on keeping good records. If you have an agenda and you have minutes, that's going to go a long way in documenting the process for making your fiduciary decision. Committees, though, should be aware, again, as we talked about before, wearing the two hats of settler versus fiduciary, what's settler and what's not. It's important to educate committees and provide training on a somewhat regular basis to make sure that they understand their duties as a fiduciary, as well as any changes in the law that will impact plans. And also, it's not a bad idea for committees to consider having a fiduciary calendar. A lot of service providers can provide these for you. You can find a lot of them online for free, and it'll just kind of helps calendar all the dates when various notices and things that are due need to be done. And again, it can make it easy for committees to just kind of go through that calendar and know in the upcoming quarter what they're going to be looking at. So that wraps it up for kind of the, what is a fiduciary and what they are responsible for and all that, the fiduciary refresher piece. So now I'll spend a little time talking about the latest and greatest guidance from the DOL. And I'm going to keep this, pretty high level. Some of these kind of go down deep into the weeds if you actually were looking at the regs or the prohibited transaction exemption. But I think it's at least important to again, flag at a high level what's going on, just so, plan sponsors and fiduciaries can be aware of what they need to be looking at. And there's also some, updates too with the Biden administration's view on these, which I'll provide at the end. So these are not all set in stone. They're still kind of subject to review from the new administration. But what I'll go through here is the new fiduciary investment advice guidance that's come out and the accompanying prohibited transaction exemption that involves the ability to, concerning advice to roll over account from a plan to an IRA. Talk a little bit about ESG investments, and the proxy voting. So to provide some context, and I talked about it before, service providers must be monitored. And it's important that fiduciaries understand the role that their service providers are playing with respect to the plan. And when we're talking about service providers, we're generally talking about trustees, insurance companies, record keepers, TPAs, but also investment advisors, investment managers, and other investment professionals. And these investment professionals, they're probably the most challenging service provider to actually monitor what's going on and whether they're complying with their fiduciary duties. One of the challenges with that group is determining whether or not they're actually providing fiduciary advice. So advisors can provide services to plans in two ways. One is to provide advice to plan fiduciaries, and one is to provide advice to plan participants. Depending on what kind of advice they're providing, there may or may not be a fiduciary. And some plan fiduciaries acknowledge their status right up front, or some investment professionals acknowledge their fiduciary status right up front. So a 331 or 338 fiduciary. By law, if you are one of those types of fiduciary or investment professionals, you are a fiduciary. But there's also investment professionals that don't acknowledge that. They're not those sort of fiduciaries or advisors, and whether they know it or not, or whether they acknowledge it or not, they might be plan fiduciaries. But again, depending on the advice being provided, some investment professionals are not plan fiduciaries at all. So it really depends on the advice. So the risk with investment advice fiduciaries is potentially usually involves prohibited transactions and compensation arrangements. If compensation, the amounts being paid to an investment professional are exceed what's reasonable, it can give way to prohibited transactions. Depending on what sort of advice they're giving and what sort of compensation they're receiving, they might not be able to actually receive that compensation without a prohibited transaction if they are a fiduciary. Of course, if they're not a fiduciary because they're not providing, just kind of providing general investment advice, then it may be fine to pay that sort of compensation. It really depends on what they're doing, their fiduciary status, and is that compensation reasonable? Now, the DOL has made a number of attempts over the years to make it easier for plan officials to monitor fiduciary status of investment advisors and investment professionals. Their most recent attempt was a pretty comprehensive overhaul of the fiduciary rules it was effective in 2016. It's been a while now. The industry spent so much time and effort getting ready for those new DOL fiduciary rules, and then shortly after they became effective, they ended up being vacated by a federal court of appeals, and all that work was for naught. So now, at the end of this year, or the end of last year rather, the DOL came back with new fiduciary guidance, and what they've done is return to their old 5-part test for whether or not you're an investment fiduciary, which came out back at the advent of ERISA. So they've gone back in time to bring back the old rule. And so for the 5-part test as to whether somebody is an investment advice fiduciary goes like this. An investment advisor or consultant who does not acknowledge his or her fiduciary status with respect to a plan will still be a fiduciary if they enter into an agreement or understanding to regularly provide individualized investment advice for a fee that will serve as the primary basis upon which investment recipient will make investment choices. So if they tick those 5 boxes, they are generally going to be an investment fiduciary, whether they acknowledge it or know it or not. In the past, there's been a number of defenses that some investment professionals that did not want to be fiduciaries would trot out as to why they did not meet the 5-part test. This time around, the DOL has addressed these defenses and largely debunked them in this new guidance. So the DOL has observed that Statements disclaiming fiduciary status will not be determinative in applying the 5-part test. So if you say you're not a fiduciary in your agreement, that doesn't mean you're not a fiduciary. But rather it's going to be a consideration in evaluating and understanding the understanding of the parties. The DOL is now going to look to whether an investment advisor's recommendations were a primary basis for planned investment decisions, not the primary basis. Before they'd say, oh no, it wasn't the primary basis. Now if it's a primary basis, it's going to be picked up. If the investment advisor makes only one recommendation, they'd say, historically, well, I wasn't providing regular investment advice. But now the DOL is saying, if you make one recommendation, and that's the recommendation, could be an interlude to a longer-term relationship, such as a recommendation to a participant to roll their money out of a 401k plan into an IRA that the investment advisor is going to manage, that might be the beginning of a regular relationship with regular investment advice. So that is not going to get investment advisors out of this 5-part test. So what do sponsors need to do? It's just important to know now with the 5-part test coming back and these additional clarifications that the DOL has given is who is a fiduciary as far as the investment professionals that work with the plan. It's likely that some plans will now have an expanded number of investment fiduciaries that they weren't aware that they had before. I think it's important to identify those individuals and make sure that there's no sort of prohibited transactions between the plan and those advisors, especially based on the compensation they receive. The plan sponsors should be, again, thinking about this and taking a look at service agreements with their advisors to see whether or not the advisor expressly acknowledges their fiduciary status. And if they don't acknowledge it, and it seems like you think they should be a fiduciary, then you should bring it up with that advisor and talk it through and try to determine whether or not they may in fact be a fiduciary. You want to look at whether or not the advisor regularly makes recommendations for the plan, and whether or not that's a primary basis for making investment decisions under the plan. Does the advisor provide guidance regarding rollover decisions to participants? If they do, they're probably going to be a fiduciary. And does the advisor's agreement accurately reflect the role the advisor plays in the investment selection process? We want to make sure that everything kind of lines up with what they say they're doing is actually consistent with what they're actually doing. Because if they go outside the bounds of that service agreement or advisory agreement and take on a fiduciary role, they will be a fiduciary, despite the fact that their contract wouldn't otherwise indicate that that's the case. I'll spend a couple minutes on prohibited transaction exemption 2020-02. This came out along with this recent investment fiduciary guidance. And this deals with, or rather as a general rule, I guess just start there, a plan is prohibited from engaging in self-dealing, or investment advisors rather providing fiduciary guidance or prohibited from engaging in self-dealing because they're fiduciaries with the plan in connection with transactions involving the plan or IRAs and plan participants. So what this new PTE does is it gives them a pass on receiving compensation as a result of advice to roll over assets from a plan into an IRA. So this typically happens, as you know, when a plan participant is terminated and they can take their money out of a plan. A lot of times, investment advisors will talk to them about, hey, it's a good idea to take your money out of this plan, roll it into an IRA that I manage. That, provided certain conditions are now met, that is exempt from prohibited transactions. So investment advisors can do that, again, provided they meet the requirements of this new PTE. And this applies specifically to investment advice fiduciaries who are investment advisors, broker-dealers, banks, insurance companies, and any agents of the above. And in order to take advantage of this exemption, they need to acknowledge and disclose their status as an investment advice fiduciary. There needs to be a written description of the services and material conflicts of interest. The nature of the relationship needs to be fiduciary in nature, which it will be if they're an investment advice fiduciary. And they need to document and disclose to the individual or the plan, if they're dealing with the plan, the specific reasons for the rollover recommendation and why, generally speaking, it's in the best interest of participants and it meets the standards, the requirements, rather, of this prohibited transaction exemption. And part of this, too, when determining whether or not it's in the best interest of participants, there's this best interest standard that's now in the PTE. And generally speaking, if they're prudent and loyal, so they put the, these are investments that they put the participants in based on, investment objectives, risk tolerance, and financial circumstances, the needs of a similar investor. If it's going to be in the best interest of participants and it doesn't place the financial advisor's interest ahead of the participants, at least with respect to excessive compensation, then it generally will meet this best interest test. The PTE is effective February 16, 2021. We'll touch on it in a minute, but right now that is still in play. The Biden administration has not gotten rid of it yet. The next bit of recent guidance deals with environmental, social, and governance funds, or ESG funds. And these are mutual funds that place an emphasis on certain themes, such as investing in maybe companies that place a high value on sustainability or the diversity or good corporate governance. They've been very popular, increasingly popular in recent years, and the DOL has made some efforts to provide guidance on them in the past. And then they rolled out these new ESG regulations, which don't actually deal specifically with ESGs anymore. The proposed regs specifically dealt with ESGs. These new regulations, the final regulations, eliminated references actually to ESGs, but they still are kind of clearly aimed at ESGs. But they also provide some other insights into things that DOL would consider appropriate as far as the process for selecting investment generally. So as it relates to the sound investment process now, with ESG and non-ESG funds, what the DOL is using instead of that terminology is pecuniary, which is monetary, or non-pecuniary considerations. So fiduciaries must now, in all cases, focus on the pecuniary factors in selecting investment options. They should not sacrifice investment return for any non-pecuniary factors. They can't supplant their own personal interests over the interests of the plan or plan participants, and they must compare investment options under consideration with alternative investment options. So as this relates to ESGs, there could be situations where the ESG principles do qualify as pecuniary, but generally speaking, the whole reason that plans are interested in investing in these ESG funds are non-pecuniary reasons, because they like what this fund is focused on. They like the message. They like it fits well with the corporate ethos of the plan sponsor. So this has really done a lot to kind of kill the ability to select ESG funds as plan investments, unless, of course, they're really comparable to other funds. So, or non-ESG funds. So when comparing an ESG and a non-ESG fund, it's got to be at least as good as the non-ESG fund based on monetary considerations to be able to select it over a non-ESG fund. And if you don't, then you've breached your fiduciary duty. So it's really important, particularly if a plan does have an ESG fund or is planning on adding an ESG fund to its lineup, to really document that process and show that, you did do the comparison between that ESG fund and a non-ESG fund, and that, they are essentially equal, and, that's why you went with the ESG fund. But again, all comes back around to documenting that fiduciary process. Some takeaways here from this ESG guidance is that, again, fiduciaries shouldn't consider non-pecuniary factors when looking at plan investments. You can't place personal interests ahead of the interests of the plan. Got to investigate multiple investment options and understand how an ESG fund might fit within the lineup. or a non-ESG fund for that matter. And again, document, document, document. The last bit of recent DOL guidance that's come out is some new proxy voting guidance. And this isn't going to affect a lot of plans, especially 401k plans. But if there are retirement plans with company stock or that invest in common collective trust, then occasionally they might encounter proxy voting requests. What the DOL has said about these proxy voting requests is that a fiduciary must act solely in accordance with the economic interests of the plan and plan participants in deciding whether or not to actually vote the proxies. That can include voting or not voting. So maybe it's in the best interest not to vote. Maybe it's in the best interest to vote. But it's something that the economic interests of the plan need to be considered. Fiduciaries need to take into account any costs involved with proxy vote. You know, theoretically, if you're doing your prudent job, you should probably do some research on that, on the matters that are up for vote, and there could be some costs associated with that. And if they're excessive, as a fiduciary, probably don't want to take them on. Fiduciaries can't subordinate the interests of participants for any non-pecuniary reasons. Also, with respect to proxy voting, they have a duty to evaluate the material facts. They must maintain records on the proxy vote. And they must act prudently and diligently in selecting and monitoring any persons chosen to advise or assist with the proxy voting. So at a real high level, they also put in these regulations 2 safe harbors for proxy voting policies, where you can potentially avoid a fiduciary liability if you meet these safe harbors. One is to always limit the vote only to specific types of proposals that will have a material effect on the investments of a plan. And that company that you're investing in itself. So if you're only dealing with material issues, then you can automatically ignore all other issues. That gives you some safety there for ignoring those other issues that are up for proxy vote. Another safe harbor is that you can have a policy not to vote on proposals where the plan's interest in the investment is sufficiently small. And you can set that, and there's some flexibility as to what's sufficiently small. But if you have a really small investment in a company, you get a proxy voting solicitation, then you can say, well, no, it's too small. Our interest in that company means nothing, so our vote essentially means nothing. We're not going to vote. If that's the policy, then you will be safe from fiduciary liability with respect to those sorts of proxy votes. So the last thing to add on all this new DOL guidance is the fact that in response to the executive order issued by the Biden administration on January 20th of this year, they are going to be reviewing all of the regulations that were adopted by the Trump administration right before Biden took office. So all of these have been picked up in their review period, and so far they have actually reviewed the investment advice fiduciary rules and the new PTE. Which is now in effect, and they have essentially blessed it and said they're moving forward with it, though they have indicated that they are still reviewing it. So it still could be subject to further change. But as of right now, that's a full go, and those rules are in place. Now, just last week, the DOL announced that it will not enforce the ESG and proxy voting regulations while it reviews them. So everything we just went through on proxy and ESG, those regulations are on the books, but the DOL is not enforcing them right now. It doesn't mean that they won't enforce them later. It doesn't mean they won't try to overturn them and propose some sort of alternate fiduciary rules, but that remains to be seen. But what this non-enforcement policy does, though, is it doesn't do rather is preclude against enforcement of any statutory requirements. So, to the extent that there's duties of prudence and loyalty requirements baked into those, that is still required. You can't avoid that just because they're not enforcing those new regulations. And the non-enforcement also does not preclude private litigation. So even though the DOL is not enforcing it, these ESG and proxy voting rules are on the books now. So if you have ESG funds and they shouldn't be there because they weren't based on pecuniary factors and you added them to the lineup, a plaintiff's attorney still could bring a lawsuit right now and sue for breach of fiduciary duty. That DOL non-enforcement will not protect you from that. So again, it's still kind of important to be aware of them and follow them to the extent possible. And the other thing that non-enforcement does is still doesn't provide any clarity on ESG investments. So really, as it stands right now, plans should not be investing, generally speaking, in ESG funds. So it's important to keep that in mind and keep those funds out of your lineup to the extent possible until there's some additional guidance. I think there's an expectation that the Biden administration will modify those rules to promote ESG investments, but again, that still remains to be seen. I think that is my last slide. Yep, that is it. So I will take a look, see if we got any questions. So it looks like we have a question about ERISA responsibilities that pertain to health insurance plans. And there certainly are ERISA responsibilities there. This was a pretty retirement plan focused presentation, but all the ERISA duties as far as self-dealing and that sort of thing, that still would apply to health and welfare plans, duties around disclosures, plan documents, summary plan descriptions, all that. Still, those are covered by the fiduciary roles for those involved with health and welfare plans. Claims appeals, those are fiduciary decisions. So there still are a number of risk responsibilities that apply to health plans, but most of this, there is a lot of overlap. You're not selecting funds, so the investment advice piece is generally not something you have to worry about, unless, of course, you had a funded health plan, but which is pretty rare. But still kind of the process, it's still important to document, work with your service providers, and again, make sure that you're just meeting generally ERISA requirements, because failure to do so or failure to follow your plan is technically a fiduciary breach. So that is all we have for time today. But yeah, have a great day, everybody. I will talk to you next presentation.